thing that's an apple and apply it improperly. So faced with the risk level of 1 in 10,000, they had Dr. Gerber do some recalculations. I call this the harmless Giardia point. What they do to get rid of the risk from Giardia, which is driving the risk that's in excess of 1 in 10,000, is they just say, hey, our Giardia is harmless. It doesn't put anybody at risk of illness. What's somewhat surprising is that when you look at Dr. Gerber's testimony, he actually said, I don't really know whether the Giardia is harmful or not. It might all be harmful, he says, at one end of the spectrum, and none of it might be harmful. So what he did is he said, I'm going to use what we do know, which is cryptosporidium can be harmful. And he used the value from cryptosporidium to produce the risks of greater than 1 in 10,000, and the regional board properly relied upon that. The fourth and final point is, I'll call it the forgotten criterion point. And now I'm talking about nitrate. There is a Federal Clean Water Act criterion for total nitrogen. It's 0.31 milligram per liter. We were glad to see that the Water Quality Order acknowledges the criterion and the legal importance and relevance of it, and said, you know what? We could have set a water quality-based effluent limit at 0.31 milligrams per liter. That would have been perfectly lawful. So when they complain that they're not given any dilution, if you divide 0.31 into 10, I think it goes about 30 times. So once again, the permit is not being conservative at all. The permit is actually relaxing a water quality-based limit that you could have set at a much more stringent level. So in conclusion, the discharger is without any reasonable basis to resist the permit. You're on solid ground upholding the permit with the adjustment to the ammonia limit described in the revised draft order. This permit is already in litigation. We're ready to defend the permit, and we're ready to defend this water quality order. Now, one final point. It's on interim measures. We urge you to send a strong signal to the discharger and also let the regional board know interim measures over the next 8 years are vitally important. There are ways to get ammonia out of the wastewater in a few years, a significant quantity of ammonia. Our wastewater expert and others have looked at a technology called side stream treatment. Side stream treatment for ammonia, according to the sanitation district, would cost about $50 million and get rid of 10% of the ammonia load within a few years. Why isn't the sanitation district moving forward with that? We urge you to encourage them to do so. Their latest statement from November 15 is that it's infeasible because of cost. It's not adding up. They ought to move forward with this, and you ought to be telling them to do so. Thank you very much.
Thank you, Paul. Bobby Larson.
Thank you, Chairman Hoppin and members of the board. And Mr. Chairman, in the interest of full disclosure, I know I asked to go before 3:45. I have rescheduled my 4 o'clock, so if you want me to sit back down and let someone else talk, I will. I just didn't want this to be under false pretenses with you. All right. Okay. Well, thank you very much. I'll go ahead then. As you know, CASA and TriTech did submit.
You should have just made her sit down with the fun of it. Yeah.
I promise to eventually sit down, if that helps. So as you know, CASA and TriTech did submit written comments, and I'm not going to go over those. You know from our letter that what we're concerned about with regard to the proposed order, and this has been touched on by Mr. Simmons and some of the other speakers, is what we see as some fundamental changes in the way that water quality regulations and laws are applied in the permitting context without the benefit of notice and comment rulemaking, which is what we are used to in terms of major policy shifts. And it's just a couple of those that are, again, in the letter, this establishment of a new water quality objective for recreational waters, the new risk factor, what we see as the application of a precautionary approach to establishing the nutrient limits. And while we would appreciate the board taking the action that we proposed in our written comments, we believe that we would not all be here today with this decision point if you were interested in remanding the permit back for some additional changes. So what I'm here today to ask you to do is simply not adopt the order. This is not a permit hearing. The permit exists, and what your order does is it says, essentially, with a few minor changes, the regional board got it right. The regional board gave the district the limits that you, or at least your staff and your lawyers are recommending to you, are correct. Typically, you would issue an order like this in a case where you want to correct something that the regional board has done, where you believe they have taken the wrong action, or where you want to add clarity to how your existing regulations and rules are applied in particular contexts. But this order does not do that, and I don't want to get into, I don't know enough to know what the particular reasons are, but I'm presuming from what's been said that there are a lot of particular circumstances here that your staff believes have warranted a different approach to this permit. So if you don't adopt this order, the permit is the permit. All of the requirements that your order is suggesting are valid would continue to be implemented. So you could avoid the concern that Debbie Webster and I and others have about what we see as really a pretty sweeping new ramifications, new policy, new practices as a result of adoption of a precedential order in this case. So again, if what you want to say is the regional board got it right, you don't need an order to do that. There's not even any petitions pending in front of you. This is on your own motion review. You've reviewed it. You've satisfied yourselves, or at least your staff and lawyers have, that this permit is essentially correct. So we'd feel a whole lot better if you just didn't issue an order and let the permit stand.
All right, Bobby. Help me understand. Yes, I did read your comment letter as well as the 73 pages from Mr. Simmons and Debbie's letters as well as others. And help me understand why adopting this order is, quote, turning our back on Porter Cologne and throwing away, you know, all the previous decisions that the board have made with respect to protecting water quality, you know, in California and developing water quality objectives. I've read all the comment letters, and I still don't understand, and obviously, you know, hearing from you and Debbie and Paul, this is a significant issue for you. Help me understand why that is.
Well, for example, the best example I can think of is in the Vacaville order, where it was a case confronted by the board and recently, by the way, upheld by the Court of Appeal. But what the board did in that case was say there is not a numeric water quality objective on point here for this particular discharge and the regulation that the regional board believed was appropriate. And you said, yes, regional board, you may regulate in that instance. You are not prevented from regulating because there's no numeric objective on point. But when you, in effect, create a permit-specific objective that you have not used before, but that you are developing in the context of this particular permitting action to address a water quality need, there is a process that you go through. You analyze the 13.241 factors. You refer to the places in the record where that information exists and that led you to conclude that that is the appropriate permit-specific objective. That's one of the examples, and this order doesn't do that. In addition, the establishment of the recreational standard, again, we're not aware of where a 1 in 10,000 risk to swimmers of infection or illness, I forget which it is, but has been used before in the state of California. So is that an appropriate standard in the context of this permit? I would defer to others. But is that an appropriate standard to then go into a precedential order that can be relied on in other permitting contexts? I would say we haven't gone through a process that would tell us that. So I guess I'm just saying, given that the order doesn't, and I know there are some changes to the ammonia limit and so on, but fundamentally the order doesn't change what Sacramento Regional is going to be required to do. So why not simply say, we're not adopting an order, the permit stands? We don't think your order provides helpful clarification to the rest of us about how we ought to interpret regulations and law going forward. And so it, in many ways, adds more confusion and more concern than simply allowing the permit to stand.
Well, we can always count on Bobby to provide intriguing comments.
Well, I would ask you to consider it because, again, what I heard the water contractor say is, we like this permit, you should allow it to stand. What I heard Mr. Jennings and Sacramento Regional say is, you should make changes to this permit, which you are declining to do. Therefore, I don't hear anybody saying we need a state board presidential order that says what yours says. So, again, that would be my request, that you give that thought.
Thank you.
Thank you.
Glenda Marsh. Glenda. Glenda Marsh.
Afternoon, Chairman Hoppen and members of the board. Glenda Marsh with the Department of Fish and Game. And essentially, I am here to express the department's support for the permit. Due to an email error on our part, our comment letter did not reach the board in time, so I'd like to read our brief letter into the record. The Department of Fish and Game appreciates the opportunity to review the proposed order for the petitions on the waste discharge requirements for the Sacramento Regional Wastewater Treatment Plant. The department offers the following comments for the portions of the order that relate to the long-term sustainability of California's fish and wildlife resources and for their use and enjoyment by the public. For ammonia, the department agrees with the State Water Resources Control Board findings regarding the final effluent limitations for ammonia and upholding denial of a mixing zone as necessary to address ammonia's toxicity to aquatic life and aquatic habitats in the Sacramento River and the Delta. Additionally, the department supports the State Water Board's commitment to continue further development of the draft 2009 ammonia criteria and the use of the latest scientific data in order to protect freshwater species and to restore the biological integrity of the Sacramento River and Delta. For nitrates, and under the topic of nutrients, the department appreciates the State Water Board's recognition of the biostimulatory effects that nitrates and other nutrient pollutants have on aquatic ecology in the receiving water body. The Sacramento River feeds into the fragile ecosystem of the Delta, and any substantial nutrient loading placed on this already stressed system presents an ecological concern for all that depend on a healthy Delta ecosystem. The department supports the Water Board's approach in this proposed order to reducing nitrogen discharges to this system. However, the department recommends that the Water Board should take into account any data or information from new and existing studies to determine whether narrative water quality objectives for biostimulatory substances are being met, even though there are currently no numeric water quality objectives for biostimulatory effects of nutrient pollutants in the Sacramento River and Delta. Finally, the department appreciates the opportunity to provide support for the State Water Board's proposed order and upholding all other aspects of the Sacramento Regional County Sanitation District discharge permit conditions. Thank you.
Thank you, Glenda. Mr. Burton, would you like to speak?
Mr. Chairman, board members, I'm Bruce Burton. I'm with the Department of Public Health. We support the action that the board is considering taking today with this order, and we support the permit that the Central Valley Board issued. We believe that our comments and our recommendations for risk level from a public health standpoint are appropriate. We have not seen the district's comments, but we still believe that in order to protect public health, the waste discharge requirements and the proposed permit is appropriate, and we would support your action. We're particularly concerned about the pathogen levels. And as was stated earlier, the specific assessment looked at Cryptosporidium and Giardia, and that's what the 1 in 10,000 was based on. The department, in its drinking water standards, uses that criteria, and from again, from a public health standpoint, we would continue to support that in this board's actions.
Thank you. Mark Bradley?
Good afternoon, Chair Hoppin, board members. I'm Mark Bradley. I'm representing the Delta Stewardship Council. Thank you for the opportunity to speak on this issue. I'll be brief. The Delta Stewardship Council previously commented on the proposed permit back in July, specifically addressing control of pathogens through filtration and disinfection. We supported the approach then, and we support it now. We also noted that filtration would help address other pollutants, including organic carbon, copper, mercury, total suspended solids, and biological oxygen demand. We appreciate that. Additionally, we supported the proposed limitations to control ammonia and nutrients. We're pleased that this proposed order addresses these issues and it is consistent with our July comments. We support you adopting this proposed order. Thank you.
Well, with all that being said, I would like to tell the world that I'm very glad I've got 2 engineers up here with me and a former US EPA Region 9 chief. So I don't know if the engineers want to start or the former Region 9.
Oh, we've already been through this. Lawyers always defer to engineers. I know my place.
Have at it.
Okay, the enviable position that I find myself in. Well, I can only bring questions from my experience. You know, I've authored NPDES permits for several years. It's been almost 2 decades since I did that. But let me begin with that. Maybe I'll direct some questions to staff, and you can help me place this in context a little bit. You know, obviously I'm very familiar, and the board's familiar with, you know, the linking the standards, you know, ultimately to the effluent limits. And I think, you know, in the report you've made some assumptions and connections. It's fairly clear to me, but I'd like to discuss some of these things. So, in my experience, and this is going back a ways, the derivation of bacterial effluent limits, numeric bacterial effluent limits, was not a classic exercise that you might see what we have in the SIP, you know, the CTR SIP, where you look at receiving water concentrations and then you derive an effluent concentration of these bacterial indicators. Not pathogens, by the way, they're indicators. And so it's more straightforward, I believe, when we're looking at pollutants. But in the case of bacterial effluent limits, my recollection in the San Francisco Bay region is we set up a tiering system based on more of a public health basis, not a numeric derivation from the water quality objective. We set up tiers, and they're here to this day, and you can go look on web and see what the limits are. But for what we call shallow water dischargers, you met what we're discussing today is like a tertiary effluent limit type requirement where there's filtration and disinfection. And in the case of deep water dischargers, we had an allowance to a higher tier. There was still numeric, but I wrote the fact sheet on these permits, many of them, and I don't have a recollection of calculating bacteria numeric effluent limits based on the Basin Plan water quality objective. So when we talk about this idea of being similarly situated, to use a term that one of the commenters used, you know, and I see Sacramento Regional's situation, you know, in the discharge environment and the type of dilution they get. I didn't find that the tiered system of numeric limits that you're proposing based on input from Department of Public Health was some kind of departure from standard practice of deriving numeric effluent limits for bacteria indicators. So my statements are in support of your approach, staff, but could you give me some examples in the Central Valley region? You know, what is the derivation? Is it numeric, or is it, you know, is it based on a tiered approach, as has been common in the San Francisco Bay region for over 2 decades?
Based on my experience actually working for the Central Valley Board, this is Rick Rasmussen for the record, they have primarily done a similar thing. They relied on Department of Health, Public Health Services recommendations to set similar tiered effluent limits based on dilution levels, and relied upon the input from the Department of Public Health to set those health-based limits to protect public health.
Okay, no, I appreciate that. I think that's important. I feel that the comments that are swirling about and you know, don't really reflect what the standard practice of regional water boards has been in deriving bacterial effluent limits. I look at the situation of many treatment plants in the Bay Area and what they do for treatment and the requirements they have, and I don't think it just didn't seem like that as much of a departure as the commenters have indicated. Okay, so let's move on a little bit. Could we have a little response from staff on the issue of hardness-based metals? You know, an issue that SPA brought up. You know, I'm a little confused. This seems like a regular treatment that this just seems like something we deal with reasonable potential analysis on a routine basis. Why, in your mind, has this risen up to a point of a petition to the State Water Board?
This has risen up in a couple of petitions to the State Water Board because there are a couple of different methodologies that can be used. There have been a couple of papers produced, and the State Water Board staff are working on a policy to clarify, you know, what are the appropriate procedures. So at this point, I believe staff looked at it and did not disagree with the way Region 5 did it in this case. So, you know, we are working on some clarity to the SIP and to that because it has risen a number of times. So that will be part of the cadmium policy we're working on currently.
Okay. Yeah, and, you know, I'm sympathetic to the commenters in that, you know, you may have a sense that you're ignored, but it's a matter of it was considered. You know, these because we did not change our recommendation or the regional board's recommendation didn't mean we ignored the comment. You know, that things are being considered. The precedent. You know, I always, you know, with this order, and maybe even legal counsel can weigh in on this, but we're considering the merits of this case, you know, or this permit as tailored, as we're supposed to do. We're supposed to tailor our regulations to site-specific conditions. The concern has been voiced by representatives of the other dischargers in the region that something that we're doing here could have some kind of precedential effect on the way limits are derived or that sort of thing. But see, that's one message I've heard. I've also heard another message that the fellow dischargers have similar requirements as you are proposing here today. So I'm struggling with that disconnect. Could you respond to that issue about the precedent for deriving both bacterial and nitrogen-related
well, in terms of the precedential effect, I mean, this is a water quality order that is meant to address these specific petitions that are before the board today. So it is, in that respect, tailored to this permit. There are certain, how do I say it, general general concepts, thank you. That's the word I'm looking for. General concepts that can be taken from this order and applied into other situations as appropriate. Now, for example, you touched on the pathogens, and that was one you just discussed. We don't think that the approach that the regional board used in this instance and that we are recommending to uphold today differs tremendously, as you stated, from Region 2 and from Region 5. Other instances, for example, Mr. Simmons brought up the issue with 13241,
Yes.
Section 13241 discussion, and I understand his arguments. I respectfully disagree with those arguments. I think we went to great lengths to phrase it correctly, that the regional board did indeed make findings, that they are supported in the record. No, I did not go through the, as it's been called, the monstrous record and point out every single instance for every single factor. And I did not say, I did not, as he, I believe, said something along the lines of overturning prior state board precedent. What I said in the order was that courts have said that 13241 in itself does not require findings. And that courts have said that the information needs to be within the record. I did not, I believe, as Mr. Simmons put it, and he can obviously correct me if I'm wrong, say that we're overturning the state board precedents and not requiring findings at all in those situations where we're being more stringent than basin plan objectives.
Mm-hmm. Okay. Yes, because I mean, it is a strong allegation that somehow, you know, the factors were not considered. I see that we've written about them. There's been some analysis, and I recognize the regional board grappled with them as well. That's, you know, that's an issue that we need to be sensitive to in terms of if the derivation of numeric endpoints from narrative objectives, you know, and where are we at least we haven't ignored 13241 in the documentation that both from the regional board and the state board. And then it's, as you say, it's, you know, he may disagree with you, and it becomes a point of how much is enough. There is a statewide context for these discussions. And, you know, as an engineer and a former MPDES author, there's a lot of context that is relevant to 13241 as far as what a myriad of other communities have done to deal with water quality challenges near their outfalls. Maybe I'll give up the floor. I mean, I might have a few more, but I want our other board members to ask some questions too, if you have any.
Well, I did cheat a little bit in that I met with staff during the lunch break. So we did go through a lot of my technical concerns and issues. And actually, we went through Mr. Simmons' letters as well. And I mean, I appreciate, I think, the concerns that have been raised by Debbie Webster and TriTac and CASA and all that. And I see Bobby back there. As much as I am tempted by your suggestion, Bobby, I think my concern is that, at least I personally did not feel that the justification that the regional board provided for the nitrate limit was appropriate. And so your suggestion would imply that we believe it is appropriate to use the MCL in that manner, and certainly, I certainly don't feel that way. So I do support, I think, the staff's finding in the proposed order that there are a lot of unique features, a lot of unique aspects to this particular permit, to this particular situation, that necessitates, I think, a different approach than we normally would use. So I'm wondering, and I'm looking at probably Mr. Laufer and James, in terms of carving out certain aspects of this order as being non-precedential. And I think Member Moore also touched upon it. Have you given any thought to that in terms of the various staff discussions?
I won't say that we've given any thought to that. I mean, obviously you see a lot of staff up here who invested a lot of time in supporting the draft order, and certainly in terms of crafting the order, going through the workshop and otherwise, the issues that were being addressed, staff had thought were substantial and therefore warranted being precedential. I think you started to encapsulate it pretty well, both in the discussion with James and Board Member Moore's discussion, that there are a lot of unique and specific, I won't say unique, there are a lot of specific facts, both relating to the pathogen discharges and the pathogen effluent limitations, as well as to the nutrients discussion, that limit the sort of precedential effect of this decision in terms of how they'd be used elsewhere. Nonetheless, I mean, the overarching principle that using site-specific risk assessments to develop or pathogen limitations is appropriate would be a message that could come from there. Whether or not the subsequent discussion and the detailed discussion, I believe that runs about 11 pages of the order, that could be used by others is fairly limited. The denial of the mixing zone for ammonia and the grounds for upholding it, which is the next major section of the order, again, is fairly fact-specific, but does provide some instruction for regional boards generally in terms of addressing these mixing zone issues. It's, I won't say whether it's a trifecta or a quartet at this point of decisions from the state board over the last few years that have had to deal with mixing zone and the denial of mixing zones and appropriate mixing zone boundaries. And I think it does advance that discussion a little bit. Whether or not others would be able to find it instructive in other permitting contexts is an open issue. The nitrate discussion, which I think is probably the one that, that's where the zone of reasonableness discussion comes in, which is drawn from federal court decisions. It's not as if it's just spawned from James's head, but the...
Yes, actually, that was one of the terms that, that intrigued me, and so thank you. Actually, we had this discussion, but perhaps for the sake of everyone else, you could perhaps fill in this whole zone of reasonableness terminology.
Well,
I really like it, though.
Well, I mean, the idea is, I'll drop a footnote here with the zone of reasonableness discussion. I mean, it does appear that people are reacting to that, but it's a recognition that there are times when the regulations lead to very specific conclusions, and there are times when the science, if you will lead to a very specific conclusion. I haven't heard anybody, and I did listen to Mr. Jennings' points, and I did listen to Mr. Simmons' points, argue that there is only one foregone legal and technical conclusion to the pathogen or nutrient issues on this permit. Instead, there's reasonable room within the law and the regulations and from the available science, and certainly in here, especially when you're talking about nutrients, there's a lot of evolving science, to make different types of decisions, all of which are reasonable. And essentially what the order that is before you today finds is that that zone of reasonableness, that range of reasonable decisions, the regional board picked an option that was within that zone and was reasonable. It could be truncated to the regional board acted reasonably, but I think it's fairly graphic what the court decided to describe, and I think it's accurate in this context. There isn't one foregone conclusion, but the regional board picked a reasonable one within that zone. So that's my footnote. Resuming with the nitrates discussion, you pointed to an important issue in terms of the nutrient discussion. There are parts of it and the nature of this discharge to a culturally eutrophic estuarine system that make it unique and perhaps wouldn't be useful in other contexts. However, there's an important lesson, I think, for all the regional boards in the early part of that discussion, and that is the importance of looking to the particular standard that's at play. And in that particular case, when in our review capacity, when we were looking at the regional board's record, it appeared that they based the determination for nutrients and for nitrate and the denial of a mixing zone for it on human health in the primary MCL, where by all indications, though, the requirements would be protective of human health. They were mixing apples and oranges, and I think that's an important point to make sure should be designated precedential and conveyed out to all the regions. And you know, some of the other, like I said, some of the other discussions that are Delta specific may not be helpful, but seeing the thought process, how the state board in looking at this record found that there was a reasonable potential to cause or contribute to an excursion above the narrative biostimulatory water quality objective, which that is the whole purpose of that discussion, is to articulate why some limitation was necessary and then to recognize how the regional board got to the point of determining what an appropriate effluent limitation would be was appropriate. Again, whether others would find that particularly helpful, that tail end of the discussion is certainly something the board could consider, not denominating that precedential. And then the final passage, there's a fourth section, and that's just the very brief public notice discussion. This is a recurring issue. The entire purpose of public notice and comment rulemaking, and in this case permitting, is to allow the boards to respond to those comments and to make changes. Sometimes it will require renoticing, but when we looked at this issue, it was certainly within the logical outgrowth that the federal courts have recognized in permitting decisions as appropriate, and we thought it was important for the state board to adopt that particular standard and for the regional boards to be able to look to it when they looked at the changes that they could make at a regional board meeting. So there's certainly, there's an appeal because obviously there are interests beyond SAC Regional that have submitted their comments on the draft order to not denominating it precedential, but there are vast swaths of it that I think are very helpful. They certainly don't take on the role of policy, which was a concern by Ms. Webster and Ms. Larson, because they are so driven by the very specific facts of this discharge.
Well, you've stated what is my hope, you know, as a board member, is that the decision with respect to the petitions is really targeted toward the order that the regional board adopted. Let's see. I think, you know, on the nitrate issue, I think staff has done a good job of articulating that this is a reasonably foreseeable consequence of managing ammonia to not have some kind of technology-based or interim-based target for controlling nitrate. I think that was key. If we didn't address that, and Board Member Dodek's point about, you know, the existing order not really tying that together in the right technical way, if we didn't address that, then I think we'd be collectively really missing the point of Port of Cologne. You know, what's reasonably foreseeable is part of what we have to look at too. We have the authority, it seems to me, to adopt the 304A, you know, stringent. Now, that's not the way I've known this board to be historically, to just take a number off the shelf and, you know, good luck. You know, we're really interested in working closely at the staff level and the board level to coming up with a reasonable timeline that's reasonably aggressive to deal with water quality issues. You know, that the point is we don't want to hold that as the way we do business. There may be in other states. We're committed, and I believe the record is clear, to a science-based process to derive numeric nutrient endpoints that are relevant to site-specific locations. You know, we've carved out the San Francisco Bay and the adjoining delta from the rest of the estuarine nutrient dependent or nutrient criteria that are being developed based on scientific information. You know, we are under pressure from the federal government to just adopt a number. This board doesn't behave that way. We don't make decisions that way. So we're committed to that as really, it's lockstep with this order, is to further develop what the appropriate criteria are. So to have a final limit at this point, it runs us down a road of, you know, issues like related to anti-backsliding and things like that, where we can't go back on a number. But if we're committed to a process, and if the stakeholders are comfortable that that process is happening and they're participating in it and it has credibility, That's important to me, you know, in terms of the follow-through from our level. So I believe it's clear. I don't speak for the rest of my board members, but that commitment to managing nitrogen with our population growth, because that's what we're talking about here. Population grew in this receiving, you know, in this sewer shed, if you will, you know, and the nitrogen mass has increased, and we have to grapple with it. And that's going on throughout the valley, and the regional board's been addressing that in other discharge permits. So that's important to me for what it's worth, the science-based stakeholder process for nutrient numeric endpoints.
Tim, you appear to still be grinding on this. Would you like to come back after a while? Francis? I know you're not an engineer, attorney.
I'm not an engineer, attorney, or former administrator of US EPA, so I'm out.
So you ran out of places to hide.
I'm just conflicted because I also used to run a wastewater treatment plant.
They told us you knew all this stuff when you came, so I want to hear it.
That's right, that's right. No, I think it's difficult. I find the way this permit unfolding is challenging. And I'm torn, I have to just say, in thinking about it, in part because I know all efforts of this kind are fraught with emotion at one level or another, but this one seems layered with emotion at every place beyond the technical, and so it's just hard to unwind it and figure it out. So that's where I'm having a little bit of difficulty with it on almost every level. But I'm not
part of the emotion, I think, comes from trying to think real quickly how many zeros there are in a billion.
I've spent $4 billion on my own for things like this, and it was the right thing to do. So I also think spending it when it's the right thing to do is the right thing to do, not the wrong thing to do. I mean, part of where I'm finding myself conflicted may not be as much in the substance, but from a public policy standard, how we explain it. And I don't know that that matters yet. So I want you guys to have more questions before we're done here. So, for example, I know this is a different kind of a set of hearings. We're not doing notice and comment on a regulation, but it is helpful when we've done the policies to see the comments and the response. I know we've talked through some of them, but it becomes very hard to sort of, I can't tell you how many times I've tried to read these papers and written comments, and the one thing I haven't done is actually charted them out on a flow chart, and I feel in a way that might be helpful. So I feel fairly comfortable that what we're doing, what the staff's proposing, is fine. I mean, it's within my zone of reasonableness, but it's not in my zone of comfort yet, in that I think being able to explain, like, for example, being able to respond to CSPA's concerns explicitly, maybe not in minute detail, would have made me felt more comfortable than Steve is with knowing we considered it and just assuming we considered it. By the same token, if you tried to go over everything that's been submitted by everybody here, we'd be tied up in knots that wouldn't, you know, there's a lot of, I won't say misdirection, but people make the arguments that work for them and what it is they're seeking to obtain. So if for some reason, it's very hard to separate the heat from the light in some of this. So I would be more comfortable if we had explained a little bit more of this in the document. And where I'm struggling with was, if from a public policy standpoint, is if I think we should try and do that again versus going with where we are right now, so that our responses to some of these things are a little clearer when they make their way where they're going to make their way inevitably from here. So that's something of concern. The other questions I had to do with is it precedential or not? And Michael, you've answered a fair number of the things that I was asking about. I'm still concerned about. One technical, and maybe it's a legal question that I have, is that in setting the interim limit, which obviously we could set at 0.31 if we were going to take something off the manual, we talk about how the NNE is in the process of being done, and it'll be done at some point in the next year or two, I think, when we talked about it. What's that impact on the treatment plant? What happens if it changes and it becomes 3-1 or 4 or 5 or something? What happens?
Right.
What,
And
what
I think
practical impact does it have
the practical
on them?
impacts are, you know, as we've been developing the NNE, the NNE specific to the plant is a little further out than a couple of years because we're still, you know, it's a very unique area and there's still science that needs to happen there, I believe. But, you know, when we've looked at it in other rivers and streams, we are coming up with what are beginning to look like pretty low numbers. I mean, if you look out in the national landscape, the numbers are coming in low. Our NNE effort on regular streams that aren't complex with the delta, the numbers are coming in low. They're coming in, you know, in the range of 1. We realize as staff that are working on this project that we have other tools because it's not just a point source issue. It's a watershed issue. It's a protection of downstream beneficial use issue. Nutrients are not like toxics. You know, they're fairly complex, especially when you get into the estuarine world. And so we are going to have to wrestle, and you all as policymakers and the final deciders are going to have to wrestle with some of these issues, which would include watershed-based work where we would potentially look at things like variances if, you know, we had to follow the federal regulations that say, well, you have to translate this number strictly, you know. I fully suspect we're going to end in a place where Florida seems to have ended, which is a multi-step process that looks at all the factors and looks at the whole watershed. I don't suspect that you would accept a policy that my staff would bring forward that would drive the treatment plants to some extreme treatment technology beyond, you know, nitrification, denitrification at this point. You know, they're not going to meet 0.31 or 1 with that technology. So staff is committed to coming up with a policy that will be a rational policy that will fall within the zone of reasonableness and use all those factors because we do have tools under the Clean Water Act. You know, the Great Lakes states did that with mercury. I fully suspect where the science is going that we're going to have to grapple with that and do something very similar.
And so I might get even more concrete if I'm the district, and you've given me 10 in this. You've supported 10. We've supported 10, however. I'm not trying to say anything with that. So they will end up with a number that's likely a lot higher than what will eventually be that limit and a lot higher than what we could be doing right now. And then, but once the NNE comes in, the question will be, how do they play in the party of the overall watershed then next time their permit gets renewed?
Correct.
All right, I just want to make sure I do
Yeah,
understand.
you do understand.
Yeah.
And you know, hopefully, as I think other board members have stated and you have stated, I believe, that they will be part and parcel of that process because it is a unique situation. You know, we have tackled regular streams and we're getting ready to take that science to peer review. We're tackling estuaries, but we did carve out the San Francisco Bay and Delta because they are, while it is, you know, a single estuarine system, all the rest of our estuaries are fairly small and less complex than these.
It's probably the most complicated system of its kind anywhere in the world, at least in this country, that I know of.
It's definitely if the closest thing we have to compare it with, probably that I've heard used is it's California's Chesapeake Bay.
Mm-hmm. No, different, but probably.
The closest.
Probably. One of the other issues that's raised a lot in the district's papers suggests a level of evidentiary discussion, our review of the district, that seems to be more than we are required to do in a case such as this. We're not, can you explain to me, Michael, and I'm sorry I didn't ask you this earlier, the evidentiary, because a lot of times people are arguing procedure in a setting where I'm not, in my experience, I wasn't exposed to that much procedure, and so the procedure that we've gone through and that the district has gone through is more similar to what I'm used to than what people seem to be asking for on all sides of this. So if you can just explain how I should be understanding this, I would appreciate it.
Well, I mean, at a fundamental level, in terms of the precision of findings that both the regional board in the first instance and then that the state board needs to make on in an order such as this, it is certainly, and the courts have repeatedly said this, the findings do not need to be drawn with the same precision that a trial court needs to draw its findings. Nonetheless, you know, as you go through the order, there were several places, and Mr. Herrick and I went through a little bit of an exercise after looking at the district's letter, where there would be assertions that there's no evidence to support this. And we would go back and read, well, that may be true in one place, but if you look back at what was not the summary, but instead the actual discussion points, there were the citations back to the record and the recognition of, on the scientifically disputed issues, for example, what the underlying study said, what the findings from the regional board were. It is not customary, and we do not go through with all of the possible administrative record citations to support our findings. Instead, as you see in the order, it is heavily footnoted, heavily documented. The evidence in the record that is relied upon by your technical staff to ultimately make the findings that support the ultimate conclusions that are in the order. And that, you know, every single document cited by the district, every single document cited by CSPA is not going to be addressed. Instead, part of the job of the order is to summarize the review of the technical staff as they go through, along with the legal staff, the various arguments that have been made. But again, as I look at it, many of the times there are assertions that there was nothing to support a particular conclusion. In fact, the order actually has extensive support for it.
And the standard that we meet, it's a reasonable basis in the record, right, that we're looking for? Or what is it? I guess what I'm trying to get at is people asking a level as if we're a trial court or an appeals court, and we're not. It's a different kind of a standard and setting.
That's correct. I mean, we do not have to defer. I mean, you all have the technical and legal expertise, and you have the support of technical and legal staff. You actually do not have to be deferential like a trial court normally does to the evidentiary findings of the agency in the first instance. And there are times where this body has substituted its own judgment on the evidentiary issues. Typically, though, we look for substantial evidence to support what the regional board did. Like I said, you have the ability to actually substitute your judgment. And then, you know, at a fundamental level, once you get past the technical issues, and it's why there's both strengths and some would argue weaknesses that come from the water board system. There are some very difficult policy calls that are being made by the regional board in the first instance and you in a review capacity in the second instance about how to plug these gaps between the regulations and the scientific uncertainty and what we should be doing in terms of good public policy as we go about addressing the discharges from the Sacramento Regional Facility. And so in those instances, obviously, that is a lot of the discussion in here. How do you weigh these different pieces of evidence that are out there? And then ultimately, how do you kind of fill in the policy gaps?
All right. Ask some more questions, because I have more. I have to look at my notes. No, I will, but I want to turn it back to Tam for more questions so I can look at my notes.
Actually, no, I was just going to say that Felicia's comment, I think, reflects my situation as well. I think what the staff has proposed is within the zone of reasonableness, but not within my zone of comfort. And not for technical reasons, but I think more for policy reasons in terms of the approaches that we're using here because of the site-specific nature of the order, the facility, you know, and the dischargers and just everything else. And so, you know, clearly the issue of precedential and what parts of this order we want to emphasize as precedential and perhaps which part do we need to emphasize as being very specific to the situation would help me attain that zone of comfort.
You know, I tried to walk through earlier what I thought would be helpful. There are 4 main sections, and
I'm sorry,
guess it's
Michael,
certainly-
you did. I guess
Oh,
my
no.
question is, how do we then document that?
Well, what we would do, and I'm sorry, I was trying to do this as way of introduction. I went through the order, and there are 4 main sections: the pathogens and nitrogen, or pardon me, yeah, pathogens, denial of mixing zone for ammonia, nitrate nutrients, and public notice. Those are the 4 overarching sections. If the board's pleasure was to only denominate portions of the order as precedential, we would simply note in a footnote that except for, and then we could, it's easier to do page numbers, but we would describe it as sections talking now, and then when the final document is prepared, it would be page numbers. This order is precedential. And so you would call out which portions would not be precedential, and that's certainly at the board's pleasure. So the working from the change sheet that is available in the back of the room, and this is just so the board members, if they wanted to flip, the pathogens discussion starts on page 4. It's pathogens and filtration. That discussion runs until page 15, where you get the denial of mixing zone for ammonia. And then from page 15 to 27, and staff, please jump in if I miss something along the way, but 15 to 27 is that discussion. Then on page 27, you start with the nitrate nutrients discussion. And then you conclude on page 39 with the public notice discussion. So if there are sections that the board was interested in not deeming precedential, you could certainly let me know that, and then perhaps a discussion amongst the board members, and then what I would do is put together the language for you, perhaps during a 5-minute break.
Yeah, actually, I could use a 5-minute break at least. What?
Well, I can put, I need direction from the board members. I mean, Ms. Dodak.
Didn't notice potential closed session, so we're trying to juggle the legality of this. Not that Mr. Simmons would ever note if we did something illegal. But, I mean, Simon.
So certainly having a public discussion right now amongst the board members as to sections. I mean, Ms. Dodak has put forward a very viable path for dealing with some of the concerns that have been raised. My sense is, from nodding that I see, is other board members are interested in at least considering that. And are there specific sections that you are interested in not deeming precedential?
I do need a break.
Let's take a break until 4:30.
Okay. Yeah. Well, it's more, because I have these questions, but I don't want to ask them now. I mean, I had a very good briefing yesterday, which is good. And then I really read the comments, and I just have a concern from a public. The answer is, we only looked at these 3 because we didn't have the resources, as opposed to what, in answer to why we didn't look at more of what Bill said. It just feels like, not always a weird bill. I thought it was an act of will for me to read his petition yesterday, because I was just concerned because he didn't file comments. The beginning of it is, there's no introduction, so it's so far wasn't anything I hadn't said up front, just emergency. You can walk away from the microphone. People here don't hear it.
You know, to a great extent, everything that is in this permit that we addressed is the same thing that's in 7 out of 8 of the permits.
Yeah, does that include the disinfection level? Everything can go down. I want to come back to it, actually, because just, and the same is true on that.
See, the way it works is, anytime, we have 2.2 and a whole bunch of permits statewide. Anytime we tell someone that you go to filtration, we put 2.2. Because that's the technology based in for filtration.
Well, I see, that's where we do 2.2, because it's technology, it's not because it should be 15 instead of 20.
No, we can't do that. You know, you go 23 if you're just going to chlorinate, and if you're going to go to filtration, and so it's just with the numbering of these, you're going to, so once the Department of Public Health says, you know, we really want these guys to go to filtration, then 2.2 is sort of the automatic number.
Right, so in essence, they're saying that both are reasonable in the sense that they meet the, what, will you explain to me the issue that they have in their brief, because I just really couldn't totally follow it, that their sewage is actually improving.
Well,
They were talking about human fecal color.
yeah, sure, they have people call it figuring, but of course that could be, you know, birds and, you know, everything else. Downstream, they examples and some good lessons. But the, you know, public health people, they don't look at it as, or, you know, we're getting rid of the fecal color form in the first place.
It's not the
We're
right.
going to the human material. And, you know, so.
Is that it, but we know we're gonna be in it, is that actually in here? We said that in here and I'm just forgetting it.
I don't know if we talk about, I think we did briefly talk about the USCPA criteria. Yeah, I think they're the ones that are coming into effect. But even if we adopt the USCPA criteria, and they are higher, if you still are in this position where the Department of Public Health says we need filtration for this, properly operated filtration is 2.2. If they're getting more than 2.2, then they're not operating their filtration safely.
Michael, or any of
And so that's why legislation is not something we give a lot of thought to. We just go, oh, this needs filtration for this license. Here's your permit, and it's too.
Yeah.
I guess part of my, I mean, there's no, I think really not helping. I mean, if I could, this is what you're seeing, this is what we're looking at. There's a part of me that feels like I only had one question. Steve ran it a little bit. So I have more responsibility to make it easier. And that was, understand who we did versus it just being setting a final. This is sort of our brand of size, which is so for public policy piece of that, I would craft it into the one that was done. I think it's pretty comfortable in that it's better for policy staff than one else. Given, not in general, because it reads really well. Okay. Then we can go back and read all the stuff. So I just, from legal, I just want to make sure that we could write it better negate those. I like it. But I just don't know how important it is to do it right now. Yeah.
I'm sure we could write it better.
Just let me
And
know.
we always think that, it's just, from my perspective, I think that legal words can change, right? And it puts us spend another 2 years better. We can spend another 2 years trying to make it better. It's just somebody going to, but they are going to become, you would have to do somebody in the allegation on it.
So what's their plan?
Well, they have tried to act as though they were equivalent to elections.
Right, yeah, that's,
And they aren't. They're discharging the Delta, something that's really important for drinking water, for all sorts of environments.
it feels like they've had a relatively free pass that they've
I mean, they're putting on a plan that was built 45 years ago. and with no real upgrades since it was first built. And this is what they scale. It's been the norm, and I think they've sort of accepted because of the fact that they had a large river to discharge there, that they would never have to